And I will switch fastly towards discussion because we have only around half an hour, 35 minutes, according to the schedule. Many issues have been mentioned, and I expect the good discussion. We got some questions written in the chat.
Maybe in the meantime, Professor Beer could answer the question that we have in the chat.
Try to address the question, which is a very complicated question for sure. It might be the key question and controversy in feminist legal studies in many parts of the world today. And I do think that gender in law can deliver what we hope for. Why is that? Again, when I say this, I mean gender as an analytical term, as a question regarding the law, not as an affirmative description of the case. You use gender as a description of the case like sex is basically the same word. It's just the more modern or advanced term often. And we see that it means a lot because it's fought against by many conservative states on the basis of the United Nations and by very conservative politicians around the world. I don't know about Serbia, but in Germany you have a strong effort by the right-wing populists to erase gender from everything. Why is that? Because they really are afraid of sex equality to happen. So sex gender in the law still works and delivers, and I think Nicola Lacey pointed out that those classic cases are not over or a subject of the past, but that we still need to understand that there are aspects of the law which discriminate directly or indirectly more often against women on the basis of sex or against men on the basis of sex. And I did not want to argue to drop that or to forget about that. This is still crucial. So my description was not, and I'm sorry to have not made that clear, a description of progress and you should forget about the past and now we're in post-categorical times. No. What I'm trying to say is that each element matters to understand stereotype, to understand intersectionality, to understand the social dimension, to understand biology. So we need to take them into a very demanding scheme into account and not say, oh, we cannot say women anymore. Sure, we need to say women where it's women because of their gender. If it's not women because of their gender, but people because of their caretaking responsibilities, then we should say caretakers. And if it's not caretakers because of that, et cetera, et cetera, et cetera. So my argument is not forget about sex in the law, not forget about gender in the law, but be more advanced in the analysis and critique of what really makes gender matter in the law. If it's caretaking, or a notion of physical ability regarding self-defense, as in Nicola Lacey's case, or an assumption of sexual availability of wives to husbands, as in the marital rape case, then it's that notion, that specific notion of gender that matters. So my argument is, or how I understand feminist legal studies today, is to be more nuanced, but not to drop gender. Another last dimension of the question is, can law deliver at all? I mean, there's this very famous quote from Audre Lorde, a master's tool will never dismantle the master's house. And the idea behind it is applied to the law, that the law has been a part of inequality, has been an active force of inequality and oppression of women and other minorities and others for the longest time. Marital rape law is one of them. So will the law help us at all? Legal gender studies, I think, are an attempt to transform, not simply kind of adapt and do a little cosmetics, but to really transform the law to be able to address all these inequalities, which is a lot more than simply adding a little tiny notion. Regarding self-defense criminal law, Nikki can describe that much better. Regarding, say, contract law, in our court we had quite a line of cases saying, the notion of contract, and you enter a contract and then you're bound, may be heavily gendered. in that women who enter banking contracts for their loan contracts for their husbands are usually totally dependent in marriage and run into post-marital debt big time, which the banks know about but didn't take care of. So we decided that formal autonomy in contracts is not enough to have you bound by the contract forever, but you have to take life situations, including gendered life situations, into account to address that inequality. So sex is in there, gender is in there, and law needed to be transformed in a very basic notion, and many civil lawyers are very critical of this move still, to address things better.
But also we can start with, maybe Amalia Verdu should take part in the conversation at the first place with with Susan, because we left it for the discussion time, that her comment, if she wants, concerning the gender approach and for solving the diversity issue in the legal context. And then all other questions regarding family law, criminal law, law and gender in general. So Amalia?
Yeah, hello. Can you hear me?
Yes.
Okay, perfect. Well, I'm Amalia Verdu. I'm working at the University of Turku in Finland.
Please, very shortly, because we have a very short time for the discussion. Very shortly, clearly, and then we will.
Okay. Well, I wanted to answer to Professor Baer because I've been defending my thesis. Actually, it was actually an analysis and research on the concept of gender and how it's used in law. So she was saying that we have to do this kind of research. I already did it. And what I wanted to say is that I agree and I disagree with her in certain points, because she really acknowledged these two different approaches to the concept of gender, but and the need to look at sex sometimes and to look at gender sometimes. But the thing is that when we look at law, this critical approach to gender, the one that considers that there is no hierarchy and that considers that that sex is culturally constructed, it never appears. It's not there. Not even in international legal texts such as Yogyakarta principles, it's not there. They always are referring to the binary of sex, and the binary of sex is there. And what happened as well is the same thing that she was saying, and I think Rosemary Hunter was actually referring to it, to the genderist subject. So using the term gender in its different acceptions, what happened is that the symbolism attached to the meaning of woman, womanhood, female, and femininity stays there. And the problem is that the exclusion of many other bodies, other people, stays there as well, because it's so linked to the binary of sex that it still reinforces the binary of sex. So what I wanted to tell her is that it's not used, the term is not useful anymore because it has the symbolism culturally ascribed to the sexes, to the binary of sexes, and it never destroys this cultural approach of sex. And it gives a veneer, the touch of neutrality and keeps this binary and femininity intact. So it's actually happening the opposite that we were expecting to do with this term and with this concept. So I think, yes, we have to be very careful how we use the concept of gender and how we use the term gender, because otherwise it happens what actually Nicola Lacey or which Rosemary Hunter has been pointing. And the problem is that we should start looking for new terms and probably start thinking about queering law and about queering the subject of law, because whatever we try to do, we still keep this sex subject in law. So we cannot really go beyond and we cannot move forward because we are using a master tool to destroy the master house. So that was my point.
This question is, I think, very interesting for all our keynote speakers, Rosemary, Nicola, Susan as well. And maybe we have two alternatives, maybe to collect a few more questions, or first to start with this gender as the term in law, whether still or not anymore. So you can decide. Shall we start with your comments or collect some other questions as well?
would it make sense to collect some questions, given that we only have a fairly limited time, and then we can sort of option which one can answer best.
So I think if questions will come later, it's also good. So Susan, Nicola, and Rosemary. Start your comments, Nicola.
Shall I just address the question that's in the chat bar? I'm sorry, I'm going to have to go in about 10 minutes. But thank you very much for that question. It's a really good question. There's been a big debate. I mean, Rosemary mentioned we're seeing this terrible spike in domestic abuse at the moment under the lockdown. Even before that, the femicide census in this country, which showed that despite a lot of political noise around domestic abuse in the last 5, 6, 7 years, actually the femicide index was very high. But I think what we're up against here, and it really touches on actually the issue raised by the previous speaker and by Susanna in her initial remarks, is that there is an enormous resistance in legal lawmaking circles, and in my experience, most judicial circles, to doing anything that explicitly punctures the surface neutrality of legal discourse. And that tells us something very important, which is that neutrality is a neutrality which is a product of and a bearer of power.
Thank you. Susan? Rosemary?
Yeah, so I'm happy to follow. I think that Nicola is absolutely right about the difficulty of shifting neutrality and the way in which neutrality is so politically important for law. But it does connect to the previous question in terms of the use of the term gender, because in some ways we're trying to do, and this is something that Nicola in particular has pointed out in her work, we're trying to do two things. So one is to critique the way that law operates now. And in order to critique the way that law operates, we have to be able to show how law does and doesn't gender its subject. So we have to call out the way in which neutrality has gendered effects. And we have to call out the ways in which gender is constructed in all sorts of damaging and constraining ways for women in particular, as well as for transgenders and gay people and all the rest of it. But so you can clear it to that extent. But then we get to the more difficult thing, which is that transformative side of the project, and how we approach the concept of gender in that context, and whether it's useful for us as a transformative tool as opposed to a critical tool. And that's where I think the sort of the arguments about queering gender come in, and I think have a lot of force. The difficulty is that we can't. We have to transform the world as we are dealing with it, rather than in order to get to the world that we want to be. And so sometimes that does mean engaging with law on its own ground, as well as trying to shift its ground. It leaves a dilemma. I don't have a necessarily good answer to that question, but I think that sort of makes sense of Amalia's dilemma and difficulty, to say that on the one hand it's absolutely necessary as a critical tool, but on the other hand, does it work as a transformative tool? Is it something that we want to use in our vision of a different world? Good question.
Susan?
Yeah, great questions, both. I think we're working on at least in three dimensions. One is critique, the academic study and understanding and excavating of law and its implicit and hidden assumptions, et cetera, et cetera. And I think this is what we primarily focused on. Then there's this other dimension, which is application of the law. And as a sitting justice on a constitutional court, that's what I do. And that when you teach law and discuss cases or decisions, that is, that's what you engage in there. So application, and I think, Amalia, your question refers to the level of application. Application is a serious problem in that all these terms and the laws we have at our hands carry the backpack of patriarchy, of oppression, and what Nicola pointed out, of seemingly neutral oppression, seemingly neutral gender bias. So yes, there is a problem. So your question, I understand, is can we transform that, or do we have to move to the third level, which would be creation of new laws? Well, I'm skeptical. Carol Smart, wonderful British sociologist, earlier on in her work, warned against the siren call of the law. Tempting to engage with the law. The law has power. Don't get swallowed by the waves when you engage with the law. But the law is so forceful that we cannot skip it. So a way beyond law or out of the law, I think, is a rather elitist project in that many people need the law and we cannot leave them alone. I might be socially sufficiently whatever to live without the law, which is also kind of an illusion, but law is a forceful element in the world, so we have to engage with the law. So if I'm there, then would there be better law, neutral law or more specific law? The neutral law we have all the time. That doesn't help us at all. And it forgets about all the fights of women's movements, queer movements, etc., which have fought a long time to inscribe their issues into the law. So I'm not very fond of that alternative. Be more specific. I'm personally working on the post-categorical approaches and think that if law would address sexism rather than sex, racism rather than race, we would advance a bit. So that is my idea for the moment. I can learn. But to understand the law when it says sex, that it's actually meaning sexism. That when it says race, it's actually meaning racism. And if I want to do a new law, would I ever be asked to write a new law, I would put the term sexism and heteronormativity and racism and all that in there to get rid of a little bit of the backpack, which is problematic. So what I'm saying is, as long as I have the law in front of me that says sex, I'd rather engage in an attempt of transformative application and interpretation, aware of the problems, of the dilemmas you pointed out, but trying to properly address the injustices out there. If I have to write a new law, I would suggest to move beyond sex and gender as terms and address the injustice, which is out there. I think we're getting better on that front, but that's up to debate. But I think to leave the tool of the master to the master is really not an alternative, because we would leave people helpless in this world.
Thank you, Susan. And now the question for Nicola. Maybe she can read it, but I will read it just for case. What does Dr. Nicola thinks about the role of femicide in criminal law in the UK, or why it hasn't been acknowledged by criminal law, despite the fact that this term was first used by Russell and Radford in the context of the US and the UK.
Dragana, I think I did try to answer that. I've tried to roll them together, and it's really is this point about the Susanna and Rosemary have also said. It's this point about the power of the alleged neutrality or universality of legal discourse, and what that universality and surface neutrality hides in actually a non-neutral way. That's the real point. And I think that's why there is enormous resistance to those with power to this form of reintroducing a categorization, a gender-specific categorization in law. I think that's why that hasn't happened.
Okay, thank you. And some other questions? I think that Amalia wanted, she asked me to,
Okay.
somebody else, who?
Margita, I have some questions.
Yes,
And
please, Marco.
No. You mentioned someone before me, so I will follow the person you mentioned before.
She has already put some questions, so we can leave her for later. Please, Marco.
Okay, thank you. I think that neutral law tends to strengthen the differences between sexes. I want to make an example stemming from laws that the Italian government enacted to face the COVID-19 crisis. In order to support business, there are special rules that want to make it easier to get loans and mortgages from banks. But this law, which is neutral, does not consider the difficulties that females face when they run business. The Italian law, in normal times, supports female businesses. In this case, we adopt just a neutral law. And as I see things, it could damage females who want to run business. So neutral law sometimes is dangerous. And I really share the point of view that it tends to reproduce differences between men and women. And in this case, this is supported by the general idea we are facing the crisis, and therefore there can be no differences. This is something very dangerous. And I think Professor Bayer was right in suggesting us to consider the pandemic era and the effects on gender and on gender law. Second point, intersectionality. And I think we have to consider also migration. Once again, I want to make a very short example from measures enacted to face the COVID-19 crisis. The Italian law supports workers who get no salary during this time because of lockdown, but it not support those who carry out house works. Unfortunately, the majority of these workers are female, and most of them are migrants. Does this law distinguishing the workers help women and women migrants? And just to consider this law, not only in light of the traditional division of labor between men and women, but also in that wider framework of migration, all those issues related to migration flows. The third point is the role of alternative dispute resolutions. These are bodies very widespread in Europe now that tend to support the parties to find a compromise. I doubt that they want to ask the parties to find a compromise, whatever it takes. In this case, I think they don't work to support female. Professor Hunter made very clear that females tend to accept compromises. So we need first bodies which are very well prepared, culturally speaking, and then bodies which are independent from society. My fear is that those who carry out mediation are not so independent to support the weakest subjects in finding a very good compromise in mediation. Thank you very much.
Serrani Siegel wants to add something to Marco's question, and then we will ask all of us to respond, but first to hear this comment. Or
Yes, thank you. Yes, I want to add to Marco's question that I think he made a very good observation. I'm currently doing a desk study where I look at the emergency interventions of many countries, spanning from east to the west, from north to the south, but more around Europe. And what I noticed is that in none of these procedures, special rules, emergency packages, never there is any kind of explicit analysis or the explicit expression like women, saying women or men. So there's never any kind of a lens, gender lens used. Many of the emergency measures, I think, do cover women especially. For example, there are many on self-employees or very small enterprises. things like that. But it never says anything explicitly about the specific situation women have as, for example, being self-employed or being a very small business owner. So, and I can really see this throughout. I'm talking about 57 countries I'm currently looking at, and I didn't find anyone mentioning any differences in we need these measures for women because, or we need these measures for men because. So this is just to really support what he was saying. Thank you.
So thank you. Other questions, comments of our keynote speakers, mutual discussion, everything is welcome.
While people are thinking of further questions, I just want to respond to Marco's point about mediation. And I think, I mean, obviously, the way that mediation is set up in different jurisdictions will differ, and whether mediators sort of have a formal role of the state or have been co-opted by the state or operate independently will differ. But I think that certainly my experience and my research suggests that mediators are committed to the value of individual autonomy. And so, the sort of great strength of mediation is that it allows people to make their own decisions rather than putting their fate into the hands of a third-party state official decision maker. And the difficulty is that they don't take a sufficiently critical approach to individual autonomy. So they don't question the extent to which somebody is actually able to exercise individual autonomy. It's assumed rather than questioned. Or to the extent that it's questioned rather poorly or superficially. And to the extent that it's responded to rather poorly or superficially. So, for example, in the English mediation context, the notion that, well, if you put people in different rooms, then there's not going to be a risk of violence. Well, okay, it's probably there's not going to be a risk of physical violence, but the ongoing coercion, control, the power dynamic is not ameliorated in any way by simply putting people in. And so I think that there are some models of mediation which have been developed which think quite carefully about how to mitigate quite serious power imbalances, but very often that level of depth of thought and the degree of modification that might be necessary to the sort of pattern of the way that mediation operates in order to adequately respond to that set of concerns is simply lacking. And it's often because it costs a lot of money. And in order to do that, you need more people. You need someone supporting a lawyer, supporting the person rather than being on their own. You need a whole lot of extra screening processes which take time and money and resources and so on. So I think that mediation is possibly capable of responding adequately, but certainly doesn't do so in practice.
May I add to that?
Yes, please.
Okay, because I think that the term adequacy, Rosemarie mentioned, is a very important one. We're talking about adequate design of institutions, of processes, and of norms. And mediation, as we see it here, is often a reaction to the lack of adequacy in court procedures. So another dimension of this discussion is to understand what courts do and what they can't do, and what people look for outside of courts. Sometimes it's speed, sometimes it's cost, sometimes it's informality, which is highly dangerous for people who are unequal in fact. But I think to look at mediation requires us to revisit courts, which is an important part of that analysis. A second brief remark is on what I think Marco said, that neutral rules are dangerous. In law, in Europe, in the United States, in international human rights law, the notion of disparate impact discrimination or indirect discrimination was invented to address that. Echoing what I think Nicola Lacey said about the resistance in the judiciary, in mainstream academics, in mainstream legal circles against critical, particularly gender or sex and queer analysis, is also resistance to accept the legal. It's an established legal doctrine to accept the doctrine of disparate impact or indirect discrimination. Why? Because it requires lawyers, courts, lawmakers, etc., to analyze the sociological, economical, and cultural realities out there. So it's part of a socio-legal addition to our usual legal brains. And that disparate impact or indirect discrimination analysis is thus such a powerful tool to do exactly what we engaged on now regarding mediation, or what we engaged early on regarding criminal responsibility. Look behind the curtain, look behind the scenes, and find out who's really affected in life by seemingly neutral laws. And I simply want to back up what Marco said, that the rules on the pandemic, particularly the economic subsidy rules, need to be analyzed regarding their disparate impact on different people in society and different types of businesses. We know from studies of banking practices and loans that women get less credit at higher costs than men usually, although their business success is better on average than that of men in a similar area of the economy. So the data actually even goes against the practice, even from an economic point of view. So to analyze this, to expose it, and then to eventually change it is part of the idea. But I just wanted to point out that we have courts accepted the doctrine of disparate impact discrimination, and it's a starting point to then do what we do, break the resistance to it, and insert the data and the nuanced analysis we need to say, if you introduce a neutral law on business loans or a neutral law on mediation alternatives, you better watch out for the de facto impact on people out there, particularly women, children, racialized people, queer people, migrants. I think that's a very important suggestion. And that's a great starting point. Thank you.
Thank you. Some more questions? So while waiting for the others, but we don't have a lot of time for many questions, but I will use this opportunity and to ask something both keynote speakers. So many times it was implicitly or explicitly mentioned that law produces reality, gendered legal subjects. So the matter of what education, implementation of law, creation of law is how to make that law create better reality, better, let's say, reality for children after the divorce, etc., etc. So in family law, in civil law, in criminal law, and generally in law. Very simplified question, but maybe you can give us some short summing up ideas.
Very simple, but very difficult question.
Simplified, please. Okay.
Gosh, a simplified answer. Well, no, I mean, I don't think that there is one answer. And I think that this is, Susanna referred earlier to Carol Smart's work and, concerns with engaging with law at all. And obviously, we've all realised that we have to engage with law because whether people like it or not, their lives are shaped by law, they are brought before the law, if that's a matter of choice or if that's because they have no options about that. And so we have to try and respond to law. But I don't think that there is any one way of doing it. I think that there are many ways that feminist activists have tried to work with law and tried to transform law or change law, and we have to keep operating on all of those fronts. So one is the kind of feminist judgments projects that Sylvia is going to go and talk about, which are about sort of trying to change legal discourse. The other is the sort of more standard feminist law reform efforts about trying to change legislation, trying to change actual rules. And in doing that, we've learned that we need to be very careful, and we need to do that in a very deliberative and consultative way, because we need to think about the ways in which laws will affect differently situated women. So we shouldn't assume that all women are in the same position and therefore one answer will be appropriate. And we can't necessarily tell what the impacts of those reforms are going to be. The other aspect of it is that if we do have a good reform, and this is one of the things that I've been working on and some of the things that my research has addressed, is that simply passing a law isn't enough. We have to make sure that it's implemented properly, which means refocusing our attention on who are the people who are putting this law into practice. Is it the same old, legal system, in which case we're going to expect it to be misunderstood or misinterpreted or misapplied. And so we have to be paying constant attention not just to what the rules are, but how they're actually being put into operation, who's involved in that, what do they know, what kind of training have they received, so that we're talking about operating across a whole range of fronts in trying to make the law slightly better, to give women better experiences of law.
I totally agree with Marie. This is a difficult question. There's no one answer. I just share an impression with you from sitting on the bench, which for me was quite a change, moving from a radical feminist activist to a critical academic to the Constitutional Court. And it took me a while actually to get it, that I'm really there. It also took many others to get over their shock that I'm really there. But so I am. So what do I miss, and what would I wish for as to make it happen? More bold, transformative lawyering. That's why I love the Feminist Judgments Project. And I wish there would be more, and we're working in Germany to install it a little bit and learn from your example. But what I mean by bold is that I meet many people who shape arguments they think we would immediately agree with. That's fine. Most lawyers do that. But please also shape arguments that move beyond from where we are. Be more radical than I can ever be on the bench. If there's no one more radical out there, I will never get anywhere. You need the bold, radical, not naive, but smart and nuanced, but radical proposals out there to find, which law is about in a democracy, a common ground somewhere in between. And I think they're not doing so bad. Nicola Lacey already said, I'm an optimist. Yeah, it depends. But look at, say, sexual harassment. 20 years ago, at least in Germany, this did not exist. It was undignified behavior and it was basically obscenity. But there was nothing about the violation of women. Now, it's in the law to promote equality at the workplace. Catherine McKinnon did that in the United States. In many other contexts, this developed from a bad joke into an injustice. That's called success, I think. Not that everything's great in that area of law, but we went somewhere. Look at the term gender justice in international criminal law, gender crime in international criminal law. This was introduced by radical feminists nobody ever listened to for the longest time. And then in the international tribunals, Yugoslavia, Rwanda, etc., feminists inserted it again and again and again and failed about 1 trillion times, but eventually found some justice, some panels, some whatever, who put it into their codes, etc., etc. Look at even, and this is for Amanda, look at queer legal theory. The word gay was prohibited of use in German parliament until I think the 80s. Now there's something like gay rights. Now there's gay marriage. Now there's et cetera, et cetera. Not that everything's good there, But what I'm using these examples to illustrate is that there is a transformative potential in radical critique. And that type of radical lawyering, which does not provide immediate success, you're not going to win a case, maybe, is going to do something to the semantic sphere we're moving in and move it into the right direction so others can hop on and use that and pretend we're all mainstream, because those radicals out there, they're even going further. So, and build arguments profiting from each other in the roles we're in. But what I sometimes miss or appreciate when it's there is bold transformative lawyering. Put radical arguments out there for me to grab them. Otherwise, I cannot do a thing.
Thanks a lot, Susan. And before we start with the second part of our conference, I want to read. I'm not sure whether the others can read it, but so I will read it. The comment of Amalia to Susan and all keynote speakers. My comment to the concept of gender is that we are using gender to kill two birds with one stone. The womanhood and the binary of sex are two independent but interlocked issues that need to be fought independently of each other. Despite the evident reasons for dissolving the binary, there is still a need for woman, but not gender, as it is better address them but their name as a specific political subject, but better name woman that categorize them as gender, which actually neutralize them. So, are there any comments to this?
Well, it will remain a controversy. It's an important debate, and these are very, very important arguments. One is, in different contexts, you need to start working with the law at hand, and if the law says sex or woman or gender or whatever, you better work with it and reform it and transform it via interpretation. If you are lucky enough to write a new law, think about what you do to not implicitly exclude anyone or have repercussions which hurt people. So, this is a debate we have to continue having.
Thank you.